appears to be an OWI 7th. Is that correct, Mr. Schmidt?
Yes.
Okay. Yeah. All right, Mr. White, what is the agreement that's reached?
Thanks, Judge. There was an offer here for plea to the OWI 7th, count 1, and also the attempting flee or elude an officer, count 2, merge and dismiss, count 5, dismiss and read in, counts 4. There was an option of requesting a PSI or not. We plan to waive the PSI and have a joint recommendation for the statutory minimums on OWI 7th with a minimum of 3 years initial confinement and the prison sentence there. The current sentence on the flee or elude charge, court cost, and supervision to include AODA and follow through.
All right, thank you. Do you have a full questionnaire?
See?
Mr. Canfield, that's the agreement that you've reached with the state?
Yes.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes.
Did your attorney go over this document with you?
Yes.
Did he go over it thoroughly with you?
Yes.
Essentially, did he read it to you word for word?
Yes.
So you understand everything on this document?
Yes, I do.
If you didn't understand something, did you have him explain it to you until you did?
Yes.
Is that your signature on the second page?
Yes, it is.
You are pleading guilty to 1 count of OWI operating while intoxicated 7th offense and attempting to flee or elude an officer. Is that correct?
Yes, it is, Your Honor.
36 years old, you have 12 years of schooling, you read, write, you understand the English language, that's all.
Yes.
You have not had any alcohol, medications, or drugs within the last 24 hours, and no mental illnesses or defects, correct?
Correct.
Did your attorney thoroughly go over with you what the state would have to prove guilt beyond a reasonable doubt for both these charges?
Yeah, we went over skill sets and so on.
Did your attorney go over with the maximum possible penalty you face for both of these charges?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on the front page of the document. Did your attorney thoroughly go over your rights with you?
Yes, he has.
And do you understand them completely?
Yes, I do.
You understand that you will no longer have the right for trial. You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty.
Right out of the gate, the judge sets the tone. This isn't just another DUI. This is OWI number 7. Think about that. 7 times behind the wheel while intoxicated. In Wisconsin, that's not just risky. That's a guaranteed prison sentence. Buckle up, because this hearing is about to balance punishment, rehabilitation, and raw human emotion.
Verdict find you not guilty, and you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up to the state?
Yes, I do.
To understand that if you're not a citizen of the United States, your plea could result in deportation.
Yes, I do.
You also understand you're pleading guilty to felonies. As such, you will no longer be able to use or possess a firearm for life.
Yes, I do.
You will no longer be able to vote in any election until your civil rights are restored. Do you understand that?
Yes, I do.
All right. Do you also understand that with regards to this matter, the state would have to prove on or around August 28th, 2023, in Gwinnett County, Wisconsin, operated a motor vehicle while under the influence of an intoxicating class F felony, and this would be counted as your 7th offense. Do you understand what the state would need to prove?
Yes, I do.
You understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 12 and a half years or both.
Yes, I do.
You also understand that with this sentence, there is a mandatory minimum, and the court shall impose a bifurcated sentence of confinement portion to not be less than 3 years of initial confinement. Do you understand that?
Yes, I do.
Do you understand that with regards to count 2, attempting to flee or elude an officer, the state would have to prove the same date, the same time, the same place, that while operating a motor vehicle on a highway after having received either a visual or audible signal from a traffic officer, a federal law enforcement officer, or a marked or unmarked police vehicle that you knew or reasonably should have known was being operated by a law enforcement officer, you knowingly fled or attempted to elude a traffic officer by increasing the speed of your vehicle in an attempt to flee. Do you understand what the state would have to prove?
Yes, I do.
You understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 3.5 years or both.
Yes.
You also understand that upon conviction, the Department of Transportation shall revoke your operating privileges for 6 months.
Yes, I do.
Now, do you also understand that there is an agreement here between the parties for a recommendation to the court of the mandatory minimums as it relates to that OWI 7 and to have a concurrence for that flee and elude? Do you understand that I'm not bound to follow those?
Yes, I do.
That means I could sentence you to the maximum possible penalty if I thought it was warranted. Do you understand that?
Yes, I do.
Do you still wish to proceed and enter a guilty plea?
Yes, I do.
Now, did you review that criminal complaint with your attorney? And in particular, there is a section there called the probable cause section, where it basically says what happened that day and why you were charged with these crimes.
Yes, I do.
For the most part, are those facts accurate?
Yes, they seem like it.
So you're admitting here today.
Here's the kicker. Wisconsin law has a mandatory minimum of 3 years in prison for a 7th OWI. That means the judge's hands are tied. No matter how sympathetic she might feel, she can't go below that threshold. Mandatory minimums take discretion away from judges, ensuring consistency, but sometimes creating tension between justice and mercy.
That you, in fact, did operate a motor vehicle while under the influence of an intoxicating 7th offense.
Yes, I do.
And you're admitting here today that you, in fact, did flee and elude an officer.
Yes, I do.
Are you pleading guilty to these charges because you are guilty of these charges?
Yes.
Mr. White, may the court use the probable cause section of the criminal complaint with statements made by your client to find a factual basis?
Yes, me, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
As far as I know, yes.
And has he discussed with you a potential of possible defenses or a lack of defenses you could have in this case?
Yes.
Did he talk to you about the discovery, that evidence, information that he received?
Yes.
Did he also talk to you about what could happen if you were to go to jury trial?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
Not that I can think of.
As to count 1, OWI 7, Class F felony, how do you wish to proceed? As to count 2, vehicle operator flee or elude an officer, Class I felony, how do you wish?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. You will find that you understand your constitutional rights and what it means to waive and give up those rights. You're going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of count 1 and count 2. Counts 3 and 4 will be dismissed and read in for sentencing. Count 5 will be dismissed and merged in with count 1. Judgment of conviction will be answered today. Argument and sentencing recommendation, Mr.
Judge, I think this is a case where the court should be doing the minimum of confinement, 3 years confinement, and then suggest 3 years extended supervision. Run the other case concurrent. You probably noticed on this one in the criminal complaint there's something peculiar with Mr. Canfield's history. First of all, his history is only the OWIs in driving inimical to public safety, which is Minnesota's version of driving without a valid license or driving while revoked. Every single one of his OWIs occurred between 2016 and 2018, so they were all within a 2-year period of time. He was sentenced on them all around the same time. At the same time, he was committed 3 different times civilly for mental illness. He's been found not competent for unspecified schizophrenia or psychotic disorder multiple times. I think in this case, timing of those commitments, 20.
Notice this moment. The judge reminds the defendant she doesn't have to accept the plea deal. Translation: she could throw the book at him and max out the sentence. This is a reality check. Prosecutors can recommend, defense attorneys can argue, but ultimately, it's the judge holding the gavel and the power.
2018, 2020, when those past OWIs occurred, the gap has decreased since then, 2018 now to 2024, 2025. I think that demonstrates that there's a connection between his drinking and driving and maintaining mental illness, and treating that. I think when he is treating it, he probably is much less likely to commit this offense, which I know is kind of unusual with this type of offense. So for that reason, I think the lower confinement period is appropriate. I think the real goal is to get him on supervision, to monitor, to make sure he's taking whatever medications he needs, he's acting cogently, he's acting sober. For that reason, I think this is the sentence that best will appropriately address him. Additionally, one thing I talk about a lot when we talk about sentencing in OWI is the whole idea of the Wisconsin plan for the OWI sentencing scheme is we keep ratcheting up each conviction, higher and higher penalty. When you have a person who just racked them all up in a short period of time, all had them at the same time, it's a little different. Like even on his last one, he only got 193 days jail in that. So he hasn't had the ratcheting up you have in Wisconsin, because Minnesota's scheme works a little differently. So for those reasons, I'd ask the court to follow the agreement. Thank you.
All right, thank you. Mr. White.
Thank you, Judge. Looking at the charges here, it's no doubt all very serious, especially the underlying facts. There's a high PAC that was received by the lab. That's merged in count 5, but it's a fact nonetheless. I'm not going to spend much time talking about facts here. It's not good. What I can talk about is my client's taking accountability. And today he's going to be sentenced after this case has been pending for about 2 years. There is some interesting information there looking at his history.
This is where the case takes a twist. The prosecution highlights a history of schizophrenia and psychotic disorders, suggesting the drinking and dangerous behavior are tied to untreated mental illness. It's a fascinating legal gray area. Do we punish the crime harshly, or do we consider treatment and rehabilitation as the true solution? What do you think? Should mental health reduce the weight of punishment?
Like the prosecutor brought up, with OWIs and competency all happening right around the same time, 2016 to 2018. I spent a good amount of time looking at the prior offenses here for Mr. Canfield because I just starting with the dates that were given in the complaint. There's a missing incident date. There's 2 convictions on the same November 20th date. At first glance, it appears there's duplicate convictions, but I did look at the Minnesota history, each case by case. Unfortunately, this is a 7th offense. He did have 5 prior offenses in Minnesota. My understanding is that he still has some supervision to go on at least 2 of those cases. This is not over with today. However the sentence goes. A strange kind of timing in this case is looking at a sentence credit and see there's a failure to appear in May of last year, and an active warrant in Burnett County, failure to appear. During that time, the client was completing treatment in Kinnick Falls Alcohol and Drug Abuse Services. There's a halfway house in River Falls. He graduated that in August 2024. So it appears that even though he was on warrant for his arrest, he still was seeking help for these problems and what led him to the OWI. I know this information because I have a certificate of completion. It was signed by the counselor there, August 1st, 2024. So just going through my client's character and rehabilitative needs, has been attempting to address this